Okay. So you want that I put it the presentation?
Yeah, please share it. Put it up. Put on.
Yeah, just the first page, isn't it? Just a second.
Yeah, the first page, and then I present you. I do the initial introduction, and then you take it from there and you move it up and down as you wish. Okay.
Okay. Yes. Here you. Just a sec. So maybe you're looking now in full.
Perfect.
Version.
Just put it in the full version, please.
Yeah, it's...
Awesome.
All right, so we have a few people waiting in the room. Do you want me to go ahead and admit everybody, or do you want to wait a few minutes?
No, go ahead. It's not going to be a lot of people, but
okay.
Let's go ahead and start on time, please.
All right, sounds good. I'll go ahead and remove the waiting room and let everybody in.
Can we start now?
All right, gentlemen, you can go right ahead.
All right. Welcome to our today's presentation. My name is Juan Carlos Varela, and I am a shareholder of our Miami and Venezuela offices. My practice focuses on international labor and employment issues in the Americas. Today is our first of several updates that the practice is going to make to the main labor and employment issues in the Americas. And in today's presentation, we are going to discuss one of the main aspects of the recent labor reform in Mexico that specifically deals with the obligatory renovation of the unions and the CBAs in the country. Today we have invited our new shareholder from our Mexico office, Jorge Sales Boyoli. And Jorge joined Littler recently, and he is a true expert in traditional labor and union matters. Jorge has prepared a great presentation for us today, explaining many things, but specifically the why of this reform, what is this reform about, and how it has to be implemented. And during Jorge's presentation, I will be asking him some of the main questions that clients have posted to us already since the reform was enacted in Mexico. And also to comment on some issues similar issues related to the same reform that happened in other countries in the Americas before this. So welcome, Jorge, and let's start when you're ready.
Thank you. Thank you very much. And thank you everybody for joining us at this presentation. Thank you, Juan Carlos, who helped us to make this possible. Thank you for all the technical team. And thank you for all of you that add to this presentation. I am very happy to be part of Littler after several attempts in the past. So thank you again. Let's begin. And Juan Carlos, please feel free to interrupt me at the moment that you feel is convenient, or at the moment that you have some questions of our colleagues in other parts. As Juan Carlos mentioned, Mexico is facing the major union reform in the recently century. In the past century, this is the most important reform. And I would like to give you a very general context about that, how we end on this great amendment. There are two important facts. The first fact is international pressure, especially of our commercial partners in the old NAFTA, that at the end of the day became on the new Usmca new agreement. Our commercial partners, especially US, argued that Mexico became very important and interesting for investments on the basis of low salaries, Mexico paying about 800% less from minimum wage than US. And the other argument that we receive of our partners is that Mexico used to have non-active union matters and non-active union activities at the company. So under that two bases, Mexico became interesting for investments. As you remember, Donald Trump explained that we stole all the jobs, that we take all the jobs from US to Mexico. That is not exactly, but at the end of the day, the fact or the true fact is that Mexico pay very low salaries, and Mexico has a non-active union industry that was part of this, that our partners say that we are making one kind of labor dumping. The other main fact that pushed up this amendment, it was a constitutional amendment that we have in the past administration, the President Enrique Peña Nieto, sorry, on February of 2017, that in one way gave us the main basis to build this new labor amendment that we have. So,
sorry to interrupt, Jorge.
Yeah.
I understand that also as part of that modification in the Constitution and the international pressure, then Mexico was one of the latest countries in the region, in the Americas, to ratify the international labor conventions with regard to union and the freedom of union, correct?
Yes, absolutely. In fact, the first legislative act that this new administration, the administration of the President Andrés Manuel López Obrador, made at the Congress, it was that you mentioned. They ratified the international agreement from the ILO, the number 1980. So yes, that is part of this new way to do all the labor and the union matters, that, like it happens in many countries, is not only a legal issue, but it's also a social and political issue. The union matters always have different blend. They have legal, they have social, and they have a political issue. Yes, correct.
Yep.
The final product of this big amendment, it was three big paths, three big new highlights about this reform. One that is related with the rapid and impartial labor justice administration. In Mexico, we have the labor boards that is not depending of the judiciary services. They depending directly from the executive authorities, president and the governors in each state. The second big path is the path that we're gonna focus today, that is in connection with union democracy and collective bargaining agreements. And the third one is, it's part of the second one, that the new reform create a new organism, create a new authority, that is this register and conciliation authority, that is a very powerful authority, because this authority will collect all the collective bargaining agreements in the country. They're gonna control all the registration of the unions. So it's a very powerful authority that still maintains under the authority of the President of Mexico through the labor ministry.
Just to make sure I understand, what it happened here is the law creates an organization that is controlled by the president of the country, that is going to supervise, register, and basically authorize unions in the whole country. Is that what the function of it is? Okay,
yes, that's correct. And that send different messages. The first messages that we can read between lines is that the government still maintain the control, the political control of the unions. But in the past, this control, it was shared with the rest of the country. And with this change, the authority, the federal authority, make one kind of takeover of all these matters. Yeah, it's correct, Juan Carlos. Thank you for that, for precise that. So we're going to put the focus, as I already mentioned it, in the union, democracy, and collective bargaining agreements. That is a part of this short conversation with all of you. Something that is very interesting is that a lot of the contents and the USMCA with the same words is right now part of our federal labor law in Mexico. That is a very important message because that shows that the labor legal matters are subordinated to the commercial agreements. So right now, the main trigger of this reform, it's for commercial reasons. So the same articles that we have in the USMCA is the same that we have on the federal labor law, as you can saw on this on your screens on this slide. So they are some freedom association matters, they are some collective bargaining agreements matters, and they are some labor justice matters. On the center, you can see the collective bargaining agreements matters. And this is the main or the central idea of this presentation. They are related that any union act will have to pass through the vote directly, secret, from the employees. So with this reform, the unions has to transfer or defer the power to the employees. Since this reform is already law, now the employees are empowered, absolutely. Not anymore the secretary or the general secretary of the union, because they can do anything without the ratification of every single employees covered by the CBA. These two main acts, they are running in two sense. The first is in connection that the ballot that will have to run for review the CBAs or to approve the new CBAs. And the other big issue on this matter is the ratification that they gave the name of legitimations of the collective bargaining agreements. All the collective bargaining agreements that we have in the country at this moment, active and non-active, will have to be ratified for the employees. So this is the big shot at the big issue. We're gonna go deep about that in the following slides. It's interesting. I'm gonna skip this slide very fast, but I only would like to mention it that this part that is in the last part of the slide that talk about that step by step. This new center that they call it Centro Federal de Conciliación y Registro. This is the Spanish acronym, but it's the Federal Register Center, will assume partially all these functions. But this is a break news because yesterday they already announced in the public gazette that this gradually will be the next month totally. So all the register functions that it's in all the country will take it since November 1 for this new center. So this idea of steps for the country for union matters is not anymore. So
I know you said that it was going to, that you were talking about this slide very fast, but what you said now, I mean, if I have a union, if I am a company doing business in Mexico and I have my union and I was planning for this second, third stage, and I said to my home mother company, don't worry, we have until 2022. So since yesterday, that means that in November we have to be ready. I mean, ready means that now we have a centralized operation. That means that the new unions are going to come into place. And I guess this is going to be discussed in your presentation, is how this law is going to change the mentality, number one, and second, how this is going to increase the number of unions being registered in Mexico.
Yes, correct. That's correct, Juan Carlos. For all the union matters that imply register new CBAs, review of CBAs, currently CBAs, and also for the purposes of the legitimation. So legitimation has a different timing, but until yesterday, before we know this Gazette new amendment, we are expecting, according this stage that you are looking in the screen. But yesterday, the authority gave us a very nice present and tell us that everybody for union matters will have to run with the new rules beginning on November 1, less than a month, half month. Yeah, thank you for that. So they are two different processes talking about the same CBA. One process is a revision that in the past in Mexico, we used to do that old fashioned. That implies that the company can have a directly settlement with the union through the general secretary, not through the employees. Sometimes it happens, it's paradoxically, but sometimes it happens that the employees are the last people who take acknowledgement that this revision is already done. Typically, the union can have agreement with the employer. They go to the labor board and submit the revision. That implies increase of salaries or benefits. Old fashioned in Mexico, every year we have to review salary, and every 2 years we have to review salary plus benefits. But now, with this new process, we require the free, direct, and secret employees vote to approval. That implies, this is a very interesting, that the union authorities will have to go with employees, and they have an assembly, and they have to be agree about the requirement that the claim that they're gonna do to the employer. Then the authority unions will have to go with the authority, not with the authority, sorry, with the employer, and say, well, this is the draft that we have for the revision. It's already agreed between employees and union. And if you are agreed, please sign. If the employer are agree, they're gonna sign it, and they submit to a website of this authority, of the register center, and the authority will have to approve. If the authority thinks that something is not right or is suspicious, the authority can order a visit to the facilities or to the plant or to the work center in order to be like expert witness to supervise the vote, because the third step of this is the vote. So the first step is the agreement between union and employees. The second will be the agreement with the employer. Third step will be that the employees will have to ratify that document through the free, direct, and secret employees vote. And the authority has the right to be on that ballot or not, in order to accept that document. And after the vote, the union will have to submit again on that platform of the authority the final document. So the revision now, it's absolutely hands-on with employees. Here, the main question is how hands-on or hands-off can be the company on this process. Because as you saw in the last slides, one of the compromises that Mexico acquired, it's that they don't have to interfere in all this process. So it's a very interesting timings challenges that we are going to face.
If I may, the description that you said about the new law, how the new law procedure is has been in place in many other countries in Latin America, in the Americas in general, for more than 20 years or even more than that. I mean, 30 years, way more than that. And now it's brand new in Mexico. So my question is, are the employees ready to have that kind of power? Is the government training, mid-level ministry is offering training to employees to organize? How companies are reacting to that? Because I can assume, and it happened in many countries in Latin America, once you have that, then you can start, getting 2, 3, 4, 5 unions in the same company discussing 1, 2, 3, 20 CBAs in the same organization. Is that already happening? Do you see that in the future? Is something that concerns you, the community?
That's a great question, Juan Carlos. I think that the short answer is no. We are facing a big challenge. We are opening a Pandora box, and that's the main concern of the companies at this moment. Everybody's working in a very fast speed in order to be prepared. I'm gonna present some statistics about that, but no, and there is a lot of challenges. We are waiting that some unions became false messiahs that appear saying that, hey, I want your vote. It's like a political campaign, you know. Everybody will be on political campaign. Human resources at our clients will have to be absolutely strategical, and not only soft strategies to have a birthday cake in the companies and that kind of things. They have to think different. So it's a big change, and nobody is ready. To be honest, the unions, they don't have structure, they don't have enough people to facing this process. The companies is the only that they have more resources, not only economical but also human, to facing this, because the authority neither have enough resources at this moment for face this process. So big challenge, and sorry for saying this term, but a big business opportunity for all of us in Littler, I think. So the other big process is the legitimation process. This is a very special and unique process because they will have only once and for only occasion, and it has to be run between May from 2 years ago until May 1, 2023. This requires a free and direct and secret employees vote approval, and it's more it's a process that will be more observed by the authority than the revisions, because they are trying to end with the non-active unions that we have in Mexico. The authorities trying to finish with this practice that is part of the claims of our commercial partners, as I already mentioned it, and is mandatory for all the currently CBAs. So in each company, we will have a ballot with all the process. The law already provides every single detail about this legitimation process. They are asking specifically for the measure of the ballot, the special measure. All that details are on the federal law, and some are mandatory ruling also. Just to give you an idea of the size of the non-active union in Mexico, I have these statistics for you. In Mexico, we have about 500,000 of CBAs. And at September, last month, they are legitimized all less than 1%, as you can see. This is very interesting and accept a lot of readings. One reading is in connection that nobody is prepared, asking your question, Juan Carlos. So everybody is working in order to shift the way that we handle the unions in Mexico. And that takes time, because this is not a human resource matter. This is not a legal matter. This is not a financial matter, because they are the three of them at the same time. So it's a big challenge again. And these numbers gave us that idea. The other very interesting idea is, from all this universe of 500,000 of CBAs, 80% are non-active unions. That implies that they are unions that in some cases the employees doesn't know that they have union. So this is a big industry, to say in a ironical way, in Mexico. because only 20% are active unions. So that's the reason that the authority is asking for this legitimation process. Talking about the legitimation process, as I already mentioned it, also revision and legitimations will have passed through the vote of the employees, and we will be very strictly observed for this Conciliation and Labor Register Federal Center to this process. What happened with this registration or with this legitimation process? As I already mentioned it, we will have to do all this process between May 1, 2019 and May 1, 2023. If these contracts are not ratified or legitimation or supported, they will die for natural die. They will be terminated automatically on May 2023. So that's the consequences.
That means, sorry to interrupt, that means that they will end, but the benefits acquired under those contracts will kept as an individual right? As
Correct. Correct. They maintain. And it's important to keep in mind that the employees will ratify the CBAs, not the union. Correct. So the fact is that the CBAs will be ended, but the union could maintain the union relationship with the company.
So to make it in a different, sorry to interrupt, to make it, to put it differently, so that means everything that is acquired already under the collective bargaining agreement is already part of the employee employment contract. And then if the same union or a new union comes, that's the floor to negotiate something better, correct?
Yes, correct. And the consequences is very interesting because this labor reform opened the door to have more than one union in the same company. In fact, we can have 3 unions because 30% of the workforce can ask to sign a collective bargaining agreement. So we can have 3 unions, and this is very interesting about the challenges that we're gonna face. Well, even the union that lost the ratification could maintain the collective bargaining agreement because here are some numbers, gain number, very interesting. To win or to be ratified these collective bargaining agreements, we need the vote from the half plus 1 of the workforce. But to ask for a new CBA, we only need the 30% of the workforce. So it's a very interesting gain number that we have to keep in mind in order to design strategy for our clients of this process, Juan Carlos.
This is very important. For me, it's very, it's like a deja vu. As you know, I come from Venezuela, and one of the reasons companies decided to shut down in Venezuela was because of the multiple unions in the same company. And one company based in Mexico, very, very big, they had 30 unions in the same company.
It's crazy, yeah.
It's crazy. So the guys that were driving the trucks had a union. The guys that were taking the product out of the truck, another union. The person that were taking the things from the port in the trunk from the port to the warehouse has another union. It was completely crazy. So it's very important for the authorities in Mexico to understand, not to limit the right to have a union, but to make sense to that freedom. Go ahead, sorry.
No, it's interesting. One aspect that is very interesting of this new ruling or this new process is that except from the ballot day, the rest of the process, it's through a digital platform. So all the process will run excepting the vote in this platform that you are looking on your screens. This is very interesting because it's an argue to try to avoid any corruption act in the process. Mm-hmm. Almost for finish, this is a very short presentation is what if, about the what ifs, if the majority of the workers vote in favor of the CBA or if the majority of workers vote against the collective bargaining agreement. As I already mentioned, if the majority of workers vote against, that implies that this document or this CBA will be ending, and the employees will conserve all the benefits as already explained and already asked Juan Carlos. And if the majority of the workers vote in favor, well, that will be a happy end, to say in one way, and they don't have to do it again. But any other union process or any union activity will have to pass through the vote of the employees, as we said. Some final consideration is that the employees will conserve all the benefits. They can have different unions. They can ask for reject any quotas, union discount, and that kind of decisions. As I already mentioned, this is the final conclusion about this process that will happen. So as I already said, the union has the right to request employer to make deductions or not make deductions. And the union also require a certificate of representation for any act. The union cannot act anymore by his own way. They need any act will need this democracy process to have the support of the worker. So as you can say, this is a big amendment from the law, but I think it's a big opportunity. Let me talk with you very short about how we are handling this process at the firm. The big companies are taking our advice in a big map route to have different steps. Sometimes we begin to make visit to the plants and try to obtain information in connection with the labor environment, because if the labor environment is not in a good position, this is not a process that we have to run. We have to work before to change the labor environment. And we have also the big challenge with the union, that the union is like the absent father that never be there at the company. And now they appear saying, well, I am your father, and I am very happy that you are my son. I never see you in 20 years, but let's know each other at this moment. So the companies are coming to Littler at our Mexican office asking for a full companion process, that they want that we run all the process hand by hand on this. And the big challenge is also how we help our clients in order that doesn't send a message that we are like a company, very hands-on on this process. We have to send the message that we are a hands-off process. And the last challenge is in connection to create all the evidence, all the proof that we are in compliance with the law, because the Usmca, as all of you know, they have a special chapter for a rapid response mechanism that they can suit any company in Mexico asking that we are not respecting this new process. So it's very important that all our clients create all the evidence in case that one of these panel will be open for a claim of US union or US company or Canadian also. So this is a very general scope about this process. I will be glad of answer any question about this process. And here is the code just in case.
Yes, I have. This is the CLA code that you have on the screen to get your CLE credit. We will leave it there. Don't just keep it there, Jorge, please, just for the people to write it down before the end of this presentation. I have a couple of. Just keep it in that slide, please, where the number is. Thanks. Just keep it there. I have a question that a client posted a few weeks ago They were looking at this, it was all over the place, all the news, so it's a public information about an automobile company that went to that process. Let's don't mention the name, but it's everybody knows what the name is. And I heard a couple of interviews from you explaining the situation. Could you elaborate a little bit more, because the client was confused about information in the news? Of course, we didn't handle that, so it's not any client information that we are revealing. How you saw that process, how it resonate on the ground, because it was a very important precedent. If you can elaborate a little more.
Yeah, you mean about these companies, how they handle, how the news, information?
The big automobile company that went through this process, huge name from the US. Don't mention the name of the company, but just basically what happened there.
Well, I have to be honest with you that at this moment we are handling like a country, I mean, with two very important companies. One that you already mentioned it, the two letters company from US, and the other is the Japanese most important company. The first one, they run this legitimation process. It's a very interesting because they have an active union. They really have an active union, but I think that something is wrong with the first steps of the process. I mean, all this scouting process that we have to do before asking to the authority for the ballot. It looks like something doesn't, it's right. The company, the union, and the legal labor advisor, that is not us in Mexico, not yet. All of them assume that they have the 50% plus one of the vote. Something is wrong on the analyze and strategy design phase, because they are sure that they can win. This process, when it begins, because it's a huge plant, they have a lot of employees, the authority decide that they have to run this process in 3 days. But one mistake that it happens for the authority, and it's a big lesson for the authority, is that they begin to announce the result of the vote every single day. So when in the first day, they announce that the trend is not in favor of the CBA, and in consequence of the union begin some acts that erase a yellow flag that they are trying to push the vote with the people. So that acts create pressure for Mexico like a country, because they open this rapid response mechanism, and the labor authority will have to avoid that process. They have to finish that process, and they have to reopen the process with international watchers, and with a lot of infrastructure in order to maintain the respect of this process according our commercial partners. So
another automobile example, was the international conflict resolution process open, requested by the union or not? Or by
not at this moment, because according to the process, there is a phase that you can offer one kind of repair plan, like us. So we don't have to go to the end of the process, because the end of the process implies a formal arbitration process, an international panel.
Just for the people to understand, in this case of the Mexican reform, because the way it was drafted and the international treaty, a domestic case, very domestic, which is a union in an automobile or any other company in Mexico, can create an international procedure in which can be other people can be involved outside Mexico, including another union from outside.
Yes.
Intervening in that process. So this is unique. I mean, this is one of the kind in the region. That's something very, very important.
Yes, very important. In fact, I can be sure that I can tell you that the USMCA is the one and only commercial trade that includes this kind of resolution panel conflict for labor matters. There is any other part in the world that they have something like that. So with this company that we are talking about, this process already trigger, but we don't have to go to the end of the process because the authority react very quick, and this is part of the compromise that Mexico will have to show to the partners, to the commercial partners, that we are respecting the USMCA. So they have to avoid the process and open a new process. And at the end of the day, the employees vote against the CBA. And at this moment, this company is facing a very interesting scenarios because the union, even the union that lost the CBA, are trying to sign a new CBA with the 40% of the employees that vote in favor of that CBA. So we are challenging a very interesting times in Mexico, and we have to be very pending of that. And the other Japanese company is not a legitimation process, but is a ownership of the CBA process, because another union that is the preferred government union, the head is Pedro Aces Barba, who is the owner of a union called CATEM, that is the preferred union of the president in Mexico, claimed the ownership to CTM, who used to be the more powerful union in the past, from this company, and they already won. So this is very interesting because we are talking in both cases from very important companies that they have a very important investments in our country. We are talking also from international labor conflict matters that maybe 10 years ago is something that we never wondering that it happens in Mexico. And this is the born of the new union matters in Mexico. So yes, we are facing, as I told you at the beginning, the major union reform in the last century in Mexico.
Incredible. And I think that the time that you are going to face right now is amazing because it's new and is what we dream when we study labor law, right? These union issues, union matters, have to solve that, and as well any other relationship with a domestic issue, with an international issue. The last question I have, just to let you go, I know you're very, very busy based on what you just told us, is that are you planning to do any specific training to employers? Because I understand from the U.S. Chamber of Commerce, U.S. Mexico Chamber of Commerce, they are looking for providers and efforts to train people on the ground to understand the new reality, how to deal with these rights that employee has to form his own union and has its own rights to decide what the CBA applies and so on. And at the same time, how to negotiate that. I know that Littler in the past, we had a joint venture agreement with Cornell University in training our attorneys and also our clients and sometimes unions on that regard in different part of the world, specifically in Latin America. Is that in your mind? Are you thinking about that, or is just not yet on your plan?
Well, it's a very interesting comment. First of all, this is an holistic matter. We have to work in different steps. We have to work in order to educate our clients on this new reform. We have to change the chip and the way that they are facing in the past. So there is a very interesting arena in order to educate all our clients or companies, high management, medium level management also, because they are on plant, on floor, in facilities, and they can handle this process directly with the unionized employees. The second comment in connection with that is that we are pretty open to participate in any different forum or university or association to explain this non-billable just at the beginning, but not billable, in order to explain this process, because I think could be a great exposure opportunity to explain this and to assess our clients.
All right, Jorge, thank you very much for your time. I really appreciate your explanation of this process, and looking forward to working with you and your team in Mexico and all the other shareholders in the office for this wonderful time for the labor and employment attorneys in Mexico. Thank you very much.
Thank you. Thank you, everybody, for spending some time. I know that all of us are very busy, so I am very grateful to all our partners and colleagues to spend some time this afternoon. I'm pretty open to discuss deeply with any of you or your clients all these new union times.
You bet. Thank you.
Bye-bye. Thank you, everybody.